Okay, good morning, everyone. Welcome to CWM. Today's mini seminar, we will talk about residential landlord's responsibility as one of a landlord and tenant relationship series. After we do this, sometimes landlord responsibility and sometimes a tenant responsibility. Because as a tenant or as a landlord, investors or professional agent, we need to know exactly what each party has to do. The landlord has a responsibility and tenant has a responsibility. By doing so, we want to reduce number of dispute or sometimes fighting each other. And there's a lot of emotions involved. Once you have a problem with the landlord or a problem with the tenant, then it becomes a very difficult situation. And also a lot of times it's involved with emotions. So the more we know, the less problems we will have. And especially as a professionals, deals with the tenants and landlord, you need to do you have to do like traffic control. We are not a cops, we are not an attorney, but a lot of people are relying on real estate professionals. They listen to what they say. Sometimes they ask what to do. So we need to know exactly what New Jersey the license law or rather real estate law requires. And okay, so title is Residential Landlord's Responsibility. I want to go over quickly what landlord generally has to do when there is a turnover, okay? The tenant exchange, basically. Number one, they have to prepare CCO, continued certification of occupancy. Well, a lot of rental cases, landlord skips this part. And sometimes, honestly, real estate professionals also skip this process. But everything is okay if it's a normal situation. But if there is any issue with the court between landlord and tenant, and if you go to court, then judge will ask first thing whether you have a CCO. And also, today's main topic, they will ask today's main topic, like security deposit, escrow account. So judge will ask first thing, whether a landlord opens the security deposit account. So CCO is necessary, even though it's very, very kind of new, in a sense, very kind of a cumbersome kind of headache. Okay, it's not a big issue, but sometimes a big issue, especially sales case, but tenant case kind of less affected, but still some town is very strict about the CCO. And second thing is, of course, all facilities and appliances shall be working order. Doesn't need to be brand new, doesn't need to be fancy, but has to be working order. Third thing, they have to usually provide, the landlord provides inspection grace period, sometimes 15 days or sometimes 30 days, which means tenant moves in the first 15 days or first 30 days. If they said, oh, this is not working and this is a problem, then landlord will fix it at the landlord's cost. Okay, so but we need to be careful. It's a functional issues, not a cosmetic issues. Sometimes the tenant got confused. Oh, the lease agreement specifies, okay, landlord will fix, if you have any problem in first 50 days, they ask a lot of different things. That's not the case. It's a functional issues, not a cosmetic issues. Okay. So typically landlord provides this inspection grace period. Now, the next one is really important, and that's today's main topic: opening security deposit escrow account, sometimes we call escrow account, and notification to tenant in 30 days. A lot of landlords, a lot of tenants, and real estate professionals do not know about this. And even though they know, they don't do. And also notification to tenant in 30 days. I think 95% of agents, even landlord, of course, and tenant does know this fact. I mean, it's a fact, but what I'm saying is it's a law. So we're going to review what law says in New Jersey. And general cleaning. Well, cleaning is a sticky issue, okay? If I looked at all the lease agreements, standard lease agreement, top and bottom, I don't see clearly mentioning about cleaning in lease agreement. So I think it's more like common sense between landlord and tenant. There's no specific clause about the cleaning. So I think if tenant's point of view, if they really care about the cleaning before they move in, they have to specify in the provision. For instance, landlord shall do professional cleaning before tenant move in, etc. Okay, so today we want to talk about specifically opening escrow account, so security deposit account, and notification to tenant. If you look at the New Jersey standard residential lease agreement, which I'm not going to bring it up, but you can take a look at item number 6. The title is a security deposit. Specifically, this section, item number 6, is based on Rent Security Deposit Act, Rented Security Deposit Act, NJSA 46-8-19. So literally, this lease agreement specifies this act, okay, from beginning to the end of item number 6. So I want to summarize that item number 6. Okay, it says security deposit amount cannot exceed 1.5 months rent. Sort of we are reading this Rented Security Deposit Act, okay? And the next thing it mentions additional security deposit amount cannot be more than 10% annually. In other words, if rent goes up, then security deposit can go up too, but annually it cannot exceed, the additional portion cannot exceed 10% per year. Okay, the next thing is landlord must open interest-bearing account for the security deposit. Okay, up to that, pretty much at least we know. And notify a bank name, bank address, account holder, account number, type of account, deposit amount. Even it says, this law says, rate of interest rate. Sorry about that. This is what I'm trying to find out every morning, but a rate of interest in 30 days after receiving security deposit, which means first thing they have to open interest-bearing account separately. That's why a landlord asks a tenant's W-9 form. If you go to bank, and then if you bring tenant's W-9 form, W-9 form, which specifies name and address and social security number, TIN number, then they will open the account with landlord name and the tenant name. But this account, landlord consign, only landlord consign. Okay. Not only you open this account, but also you have to notify all these details information to the tenant in writing in 30 days after you're receiving the security deposit. Later on, I'm going to show the samples. And also, it says, this law says, which means this lease agreement says, interest on security deposit must be paid at the renewal date. Okay, after 1 year, if they renew, they have to pay the interest. Or January 31st, every January 31st, if notified so. They can agree. The interest will be paid January 31st. But already you will say, you will think, wow, this is too much. Who is going to do this? Yes. The reality is different from the law. Okay, law, I'm just introducing the law specifies. And also that is actually what you agreed between landlord and tenant agreed, because it is the part of New Jersey standard lease agreement, whether you like it or whether you know or not. Okay. The next thing is specified is when the property is sold, landlord must transfer security deposit and undistributed interest to new owner, and again, notify tenant the conveyance, the deed transfer, which means closing, within 5 days after the closing. Okay, that's what the law says. The next item is a landlord shall return security deposit plus undistributed interest, less any charges expended by landlord for damages in 30 days after tenant move out. So I think roughly we know this. Okay, tenant shall return security deposit plus undistributed interest, but minus any charges expended by landlord for damages in 30 days. Okay. And the next thing is a landlord must send a written letter with itemized interest and deductions along with the balance of security deposit by registered mail. Okay, is not what I am saying, is what this law says, and this lease agreement specifies exactly according to this law. Okay, so landlord has to do that. And if there's no problem, if you have a good relationship with the tenant, landlord and tenant, they very happy, then the landlord receives the monthly rent in time, then there's no problem. But again, if there is problem, if the litigation arises, if you go to court, then the judge will know all these laws. They're specialized in laws. So judge can ask, did you do this? Did you do that? Did you do that? So that's why a lot of tenant eviction case, okay? If you bring this case to the attorney first, so you have a consultation with the attorney, then attorney, some smart attorney will ask first, did you open the security deposit account? And then landlord says no. And then a lot of attorneys, they don't want to touch, because if they go to court, the judge will ask first thing, did landlord open the security deposit account? And then they say no, then from that moment on, the landlord are in not so good position. Okay. And as a sample, the letter, I want to try to bring up this sample letter. Let me see, I can do this part. Okay. Okay, it's a typical letter, but you need to notify. Once you opened a bank account, okay, with the tenant's W-9 form, actually landlord has to go to bank. That's kind of pain in the neck. Okay, every tenant turnover, you have to go to bank and open up separate account. So bank name, bank address, and account holder. Typically, there are two account holders, tenant and landlord. But as I said, landlord consigned the check. And the account number and type of account, saving account. It has to be interest-bearing account. And the deposit amount. Now, as I said, the law specifies that you have to spell out interest rate, but this sample letter didn't include interest rate because it becomes too much, honestly. Okay, so I didn't specify, but we kind of searched typically 0.03% interest, not 0.3%, not is 0.03%. So basically throughout the year, maybe a few dollars, less than a few dollars. So sometimes law is ridiculous, but law is law. And so you can just say that, in other words, as a landlord, I opened up this account for your security deposit money, and this is a bank information. That's what you have to notify to the tenant, okay? And then you signed, and you maybe CC to the agents, if agents were involved, okay? I think that's pretty much it. I want to summarize in Korean. So, 랜로드 입장에서 해야 될 몇 가지 중요한 게 있는데, 우리가 테넌트를 맞이할 때 CCO를 꼭 받아야 되죠. 그래서 꼭 받아야 되는 얘기하면은 예스라고 대답할 수밖에 없지만, 실질적으로 테넌트가 턴오버될, 테넌트가 바뀔 때 CCO를 받아야 되는 건 맞고요. 그러나 이렇게 스킵하는 경우도 있기는 한데, 받는 게, 모든 게 정확하게 하는 게 좋기는 좋겠죠, 당연히. 네, 받아야 됩니다. 이렇게. 그리고 당연히 무슨 포슬리티들이나 그 어플라이언스가 이제 워킹 오더야 되겠고요. 그 다음에 보통은 랜로드가 처음에 한 first 15day나 아니면 first 30day는 고장난 게 있거나 그럼 다 얘기해라. 랜로드 익스펜스로 다 고쳐준다. 이런 클로즈를 넣는 게 보통이죠. 근데 테넌트들이 오해하는 거는 이게 코스메틱 이슈는 아니고 절대로 펑셔널 이슈라는 거를 아마 명시해 놓으면은 상당히 서로 분쟁이 없을 것 같아요. 그리고 랜로드가 할 중요한 사항이 소셜 시큐리티 디파짓 어카운트를 열어주는 거. 그리고 열고 끝나면 되지 않고요. 법적인 상황에서 30일 안에 테넌트한테 또 편지를 보내줘야 된다. 제너럴 클리닝은 굉장히 스티키한 이슈다. 왜냐하면 리즈 어그리먼트를 아무리 들춰봐도 클리닝에 대한 어그리먼트가 나와 있는 게 없어요. 그러니까 그것은 좀 커먼 센스 레벨에서 랜로드하고 테넌트하고 얘기를 한다든지, 아니면 테넌트 입장에서 뭐 프로비전에다가 스페시파이를 꼭 한다든지, 무브인 하기 전에 프로페셔널 클리너를 꼭 쓴다, 이렇게 명시를 하는 게 좀 덜 문제를 발생시키는 것이다, 이렇게 볼 수 있는데, 오늘은 특별히 리즈 어그리먼트, 스탠다드 리즈 어그리먼트에 아마 그 세미나 끝나시면 한번 보세요. 리즈 어그리먼트를 한번 꺼내서 아이템 6에 가면 시큐리티 디파짓이라고 딱 나오고, 그리고 그 시큐리티 디파짓에 대한 조항은 이 법에 의해서 렌트 시큐리티 디파짓 액트 이 법에 의해서 이제 집행된다라고 아주 써 있어요. 그러니까 그 사실은 법령을 거의 그냥 카피해 놓은 거예요. 이 아이템 넘버 6는 리즈 어그리먼트 상에. 그래서 다 아신 대로 그 시큐리티 디파짓은 1.5만원을 넘지 못한다. 뉴저지에서는. 그리고 어디셔널 시큐리티 디파짓 필요할 때는 1년에 10% 이상은 못한다. 그리고 이제 오늘의 토픽 은행 가서 테넌트의 W9 폼을 가지고 은행 가서 시큐리티 디파짓 어카운트를 열어줘야 되는데 인트레스트 베어링 어카운트 열어줘야 된다. 머니 마켓 어카운트, 세이빙 뭐 이런 인베스트먼트 어카운트 해야 되고요. 그 다음에 중요한 게 테넌트한테 알려줘야 돼요. 뭐를 편지로 여기 디테일한 인포메이션, 네 돈이 어디가 있고 얼마고 심지어는 law specifies 그 법적으로는 interest rate까지도 기록을 해서 편지를 30일 안에 보내줘야만 된다. 그 다음에 사실은 여러분들이 어그리한 게 뭐냐면요. 이자를 리뉴얼 데이트에 페이를 해줘야 돼요. 아니면 1월 30일로 어그리하면 그때 보내주면 돼요. 자, 또 뭐가 있냐 하면은 만약에 프로퍼티가 솔드 됐어요. 그 테넌트는 그냥 남아 있는 거죠. 그때의 랜로드는 다 트랜스퍼, 시큐리티 디파짓을 트랜스퍼 해야 되고 또 그동안 지불하지 못한 이자까지 새 오너한테 트랜스퍼 해줘야 되고 그 다음에 반드시 테넌트한테 클로징 5일 전까지 그 인포메이션을 다 또 보내줘야 돼요. 그 다음에 이제 랜로드가 시큐리티 디파짓을 테넌트가 무브아웃하고서 30일 전에 시큐리티 디파짓을 되돌려줘야 되는데 거기다가 그때까지 아직 주지 않은 인트레스트 플러스시키고 그 다음에 이제 그게 굉장히 유명한 거죠. 이거 charges expended by landlord for damages. 무슨 데미지가 나서 랜로드가 고쳤다 하면 그 경비를 마이너스하고 테넌트한테 이제 보내준다. 그런데 그때의 랜로드는 반드시 이걸 리턴으로 아이터마이즈를 써야 돼요. 이자가 얼마, 그다음에 뭐 데미지 난 거 얼마 이렇게 써서 그걸 빼고 나머지 밸런스는 레지스터 메일로 반드시 보내줘야 된다라고 하는 조항이 그 리즈 어그리먼트의 6번 아이템에 들어가 있다. 그 어카운트 여는 거는 대부분이 아셔서 알고는 있죠. 알고는 있는데 잘 어카운트를 안 여시는 경향이 있다. 그런데 법적으로 문제가 돼서 코트에 가려면 간단히 얘기하면 테넌트가 결국은 잘 안 내네요, 렌트를. 그래서 에빅션을 가려고 하면 요즘은 변호사들이 처음 물어보는 게 그거예요. 그걸 케이스를 맡으려고 그러다가 처음 물어보는 게 자꾸 저는 소셜 시큐리티라고 하는데 시큐리티 디파짓 어카운트 열었습니까? 이렇게 물어봐요. 그래서 그걸 안 열었다 그러면은 에빅션 케이스를 잘 안 맡으려고 그러더라고요. 변호사님들이. 그래서 그런 경향이 좀 있으니까 귀찮아도 테넌트 바뀔 때마다 테넌트 W9 폼 가지고 한 번은 은행을 또 가셔야 돼. 그래서 열어놓는 것이 세이프하다. 근데 왜 이런 법을 이렇게 강하게 해놨을까요? 그건 이렇죠. 대개 랜로드들이 시큐리티 디파짓을 받아가지고 자기 돈 생긴 것처럼 내 돈 생긴 것처럼 내 체킹 어카운트에 넣어놓고 써버리면 어떻게 되겠어요? 나중에 뭐 생활하다 보면 뭐 쓸 수도 있잖아요. 그러니까 써버리면 나중에 이제 시큐리티 디파짓 되돌려 줄 돈이 없잖아요. 없으니까 어떻게 한다? 이제 아주 억지를 쓰는 거죠. 그러니까 테넌 보호예요, 일종의. 그래서 랜로드가 억지를 쓰는 랜로드들도 꽤 많아요. 억지를 써가지고 이것저것 다 떼요. 그리고서는 뭐 못 들려준다 이렇게 나가면 이제 문제가 생기는 거죠. 그래서 법으로 아예 절대 시큐리티 디파짓은 터치 못하게끔 은행 어카운트를 따로 만들어서 넣어놓게 하는 거죠. 오케이. 그 커버가 됐고요. 그 다음에 아마 이 인트레스트를 페이를 매년 해야 된다는 거, 리뉴얼에 그런 것이 좀 새로울 거고요. 그 다음에 이 은행 어카운트 오픈을 하는 것도 중요하지만 당연히 해야 되고 또 편지를 하나 보내줘야 된다. 그래서 아까 편지 한번 보여드렸죠. 샘플로 그런 편지를 만드셔서 보내줘야 된다. 그렇게 해야 완벽하게 랜로드의 일이 끝나게 되는 거죠. 테넌트 한 분이 들어왔을 때. 오케이. 여기까지 하고요. I think this is it for today's mini seminar. Well, if you have any questions, you can send the chat to me or, of course, the email. My email is available. So anyway, the landlord-tenant issues goes forever. I think we are not gonna leave the world without a landlord-tenant problem because, as I said, in the world there are two kinds of people only. In real estate point of view, the group of landlord and group of tenant, and it goes forever. So we need to know exactly what landlord has to do and exactly what tenant has to do. Okay, that's it, and I hope I will see you all next week.